You're watching For the Record here on the Law and Crime Network this Friday afternoon. Aaron Keller along with you for the next hour as we break down now a case that's expected to start Monday with jury selection. This is the case of Michael Drejka. It's a Florida case, and it's a case involving elements where the defendant says he was defending himself in an attack perpetrated by the victim. The victim shoving the defendant in a parking lot after the defendant asked the victim's girlfriend why she was parked in a handicapped spot without a permit. There's the defendant on the left side of your screen asking about the parking spot. There's the victim coming out, shoving the defendant to the ground. The defendant pulls his concealed carry gun. He had a permit. He fired. The victim turns and heads back inside the store. The victim ultimately died. So it's a question of culpability. Is that a crime for which culpability attaches to the defendant, Michael Drejka, who was on the ground, pulled out his gun, shot, fired, and killed the victim? Or is it self-defense? Well, we're going to get some perspective on that from Kirk Burkhalter, a New York Law School professor who analyzed the recording for Law and Crime.
So in the surveillance video, the defendant approaches the victim's car, which is parked in a handicap zone. The victim comes out and knocks the defendant to the ground. At that point, that's when the defendant drew a weapon. Now, a key point here is that once the defendant drew his weapon, the victim took one step back. So if you freeze that moment in time, the threat was over. Theoretically, the threat could be over. However, the defendant continued to shoot at that time. Certainly, he's going to argue that he felt threatened. But as law enforcement reviewed the tape, that's a split second. So it's a matter of, did the defendant have time to really think that the victim was retreating or not? First of all, this standard is reasonableness. So for instance, if someone walks up to you and asks you what time it is, and that person is a 90-year-old elderly person, and you take out a weapon and shoot them, that's unreasonable, right? It's unreasonable to say, well, I felt threatened. So the first stop on the train, so to speak, is reasonableness. Was the threat, was this, and that's an objective standard, this reasonable person that doesn't exist out there. Next would be the proportionality of the force. And this is something that we've seen in the Trayvon Martin case, and we will see in this case also, where that's what's going to be under contention. So in both cases, the victims were unarmed, and here the victim, both defendants were armed, and they ultimately used deadly physical force, causing the death of their victims. So law enforcement will first look at the reasonableness of the perception of the threat, the proportionality of the use of force, and finally, the totality of the defendant's actions. Was the defendant the initial aggressor? So for instance, in this case, while the defendant started this entire situation by approaching the vehicle, the defendant was not the initial aggressor with the victim. Arguably, the victim was the initial aggressor because he pushed the defendant to the ground. So those are some of the key facts.
Let's bring the panel into this discussion to try to figure out exactly what we're looking at in that video that we watched, the surveillance video. So Eklund Mercy back with me now from Atlanta, Georgia. Our new guest, Matthew Maddox, is joining us from Connecticut. So Matthew, you watched the video along with me off the beginning there. What's it tell you? Is this self-defense or is this a criminal act?
I'm afraid it's a criminal act. I think that under the circumstances, applying the reasonableness standard, you've got a gentleman, certainly that was a very hard push. The man fell, but under a reasonable analysis of the circumstances doesn't justify the degree of force used here, that is pulling a weapon and shooting at the man. I think that even if he's stepping toward you, unless there is a weapon that's being brandished, I don't think firing a firearm back at this man was justified under the circumstances.
Eklund Mercy in Atlanta, Georgia. What's your take on this?
Well, I think that the victim in this case actually was defending his girlfriend initially. So by pushing the defendant to the ground, he was defending his girlfriend. You have a man who is yelling at your girlfriend in the car to the point that she gets up and gets out. So he pushed it to alleviate the situation. And as Mr. Burkhalter stated, that it wasn't reasonable because as soon as he pulled out his gun, you saw Mr. McLaughlin step back. And at that moment, the threat was diminished, and there was no reason for him to shoot him.
Yeah, okay, so we've got a lot of questions for the jury to try to unravel here. One is exactly who is the first aggressor, and I think we're seeing some of that in the discussion here. And then, is this justified? So a lot for a jury to look at. Jury selection starting on Monday. Let's listen now to Sue Ann Robinson. She was here on the Law and Crime Network with us yesterday. She works for the law firm that represents the victim's family. Here's her analysis of this matter.
If you recall, in the beginning, the defendant was not even arrested. They let him go. He slept that night in his bed very comfortably while Mr. McLaughlin was dead, and his family had to deal with that. So after getting over the initial shock of almost feeling like nothing was going to be done, I think now she feels like she has community support, she feels more empowered, and she's on the train of, you know, justice might be slow in this case, but it is coming. Every day she tries to honor the legacy of her boyfriend, the father of her children, who lost his life essentially protecting them from a stranger. And so she does her best every day to just honor that legacy and teach her kids, her new baby and her smaller kids, you know, keeping his memory alive. I think it's completely inappropriate for him to say it's self-defense. I think the real key and the thing that the prosecution has to try their best to bring out is that he was a gas station vigilante. He was at this gas station harassing people all the time. And there's records that show that the police had been out there previously to deal with him and him approaching people in the gas station. So to the extent that the prosecution can bring out that this was almost a pattern, I think his self-defense will kind of melt away for the jury.
A couple of different perspectives on this case. So Eklund Mercy, part of our panel this afternoon here on the Law and Crime Network. Your reaction after hearing that from an attorney working with the firm who's representing the family of the victim who lost his life in this encounter in Florida?
Yeah, it makes perfect sense. Remember, this is Florida. This is where the Trayvon Martin case transpired. So you have just older gentlemen just yelling at you for this parking spot. He has no dog in this fight. So when he sees that, when McLaughlin sees that, he then defends his girlfriend, and what he got was murdered. We have to stop. We see there's an alarming pattern of, you know, parking lot peep. We have the, as the attorney said, this is a gas station vigilante. We cannot, I don't think Florida cannot keep having people just take the law into their own hands.
Okay, so a reaction to that, now Matthew Maddox in Connecticut, what's your take here? I mean, I think this is going to potentially be a difficult one for the jury to try to unravel, but where I'm going with it is the turn in the video where the victim who lost his life here turns, and exactly what point in that recording was the shot fired. I think, as it is with many of these other instances, the video is going to have the answer in a contested situation like this.
I think a great deal is going to depend upon the jury composition. The jurors in this case, who is picked, what their background is, what their perspectives are going to make a tremendous difference. You're right. I think that pivotal moment is a huge moment in the evidence. I also think that it's unfortunate that this gentleman, it's a tragedy, of course, but it's also unfortunate that the degree of force that he used was exaggerated as well. I understand that he felt that his girlfriend was being harassed or being troubled, but that force that he used, that shove, that was a really, really violent push that threw that man down onto the ground. I think is also going to also be a factor that's weighed very heavily by this jury.
I would push that fact if I were the defense in this case, certainly. And one of the other defense theories we're hearing is going to come out of this is that the defendant, Michael Drejka, said that, look, there's like a zone of a certain number of feet around me that my self-defense training has indicated that that's when I'm in danger, and that the victim in this case was within that zone. That may sort of muddy the water in this or make the case a lot more complicated. So bottom line, jury selection in that case is going to pick up on Monday. Opening statements could happen at any time. Of course, sometimes juries take a while to seat. Sometimes they're seated very, very quickly. So we're going to be monitoring that very closely on Monday here on the Law and Crime Network. We're going to be back in just a moment here on Law and Crime with more discussion about a case we brought you this past week. This is the Joe Key case, where there was a shooting over, of all things, a noisy neighbor. Why did this alleged noisy neighbor lose his life, allegedly because of noise? Some answers after the break.